Hello, 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 beautiful people. Welcome back. Public Law 90-321, May 29, 1968. To safeguard the consumer in connection with the utilization of credit by requiring full disclosure of the terms and conditions of finance charges and credit transactions, or in offers to extend credit. This first clause relates to anything where someone is saying, I'm now going to be your creditor. You and I are going to sign this paper. Or maybe just you only are going to sign this paper because we know you're desperate. You need this thing called a house. You need this thing called a vehicle. You need this thing called a credit card. You need this thing called a line of credit, either they're revolving or not. So now you're going to sign it, and we're going to be something called your creditor. Because by this agreement, we basically become your God. We create the money. And you consent that that creation of money makes us the creditor. And you, on the other hand, you basically give us cash flow monthly. And if you're smart enough to pay off the principal, good. If not, just keep paying the interest for about 25 years. And anywhere along the line, if you make a little bit of mistake, we'll take the collateral which you own, and we'll take all your monies which you've given us. That's in summary what this first clause has said in layman's terms. And then the next clause goes on to say things that benefit you by putting colon, meaning despite all this, or in relationship to all this, by restricting the garnishment of wages, meaning we know the so-called creditors that most people enter into some type of agreement with, or purchase agreement, or other type of memorandum with, they usually have this tendency to want to basically take people's labors. So now we're going to create something relating to those affairs by restricting it. We're not going to annul it. We're not going to stop it from occurring, but we'll restrict it. And by creating National Commission on Consumer Finance to study and make recommendation on needs for further regulation of the consumer finance industry and for other purposes. Always keep in mind, whenever you see at the end of any given clause, any given introduction, any given section, any given chapter, within any quote legalese that says for other purposes, know that these other purposes are the things that actually truly benefit you. It's the reason why they usually put it towards the end and make it vague. Finance industry, meaning anyone that says, all right, I'm engaging in the business of banking. Presumably those on Patreon watching this will know the difference between bank and banking. And the industry is basically any given nature of business that is well known and well connected and well associated and linked with one another to make ends meet based on this first clause. This National Commission of Consumer Finance is not like the Consumer Financial Protection Bureau, where people are under the impression that you can go make a complaint with them and they'll sue on your behalf. On that note, Consumer Financial Protection Bureau only sue on behalf of large corporations. It benefits them. On behalf of the everyday man, you're just typing a lot of things and sending a lot of papers. That's all you're doing. The National Commission of Consumer Finance, on the other hand, does not even presume itself, based on how it's established and its purpose, aka the intent of Congress, to do any such a thing even close to the Consumer Financial Protection Bureau. All it does is just act as a census of the said industry. And of course, it's an inside thing. Many things that we see in today's world constitute two main things: ownership and control. People who love football, whether they're international football or North American football, people who love hockey, people who love basketball, people who love tennis, And these things are only being used as examples because it's well known and it's broad and it's easy to relate to, regardless of who you are. Even if you don't watch these sports, you've heard of it. And these examples might be easy to grasp. And even if it's not relating to sports, it might be, well, a house. You walk down any street, you travel down any city, you see them everywhere. They are in abundance, just as much as all these sports teams. You see vehicles everywhere. You see towns, you see cities. All of those existence where human activities are involved constitute two things at its core. Those two things are ownership and control. People who say, oh yeah, the so-and-so name of a team is my team. Yeah, that's my team. Look, I have the jersey on. Look, I have their banner in front of my house. That's my team. Those are my boys. Right? Right. That's your team, all right. People who live in apartments of land called houses, they say that's my house. People who go around in vehicles say that's my car. People who say, I live in so-and-so city. Oh, that's my town. Right. Well, that's ownership. One of the two main attributes involved in every human activity and any objects involved in it. But then there's this thing called control. The people that control those sports teams that many people claim is theirs, the people that control the mortgage industries that are using those houses as collateral, and many people are saying those houses are theirs. The many people who control the finance industry when it comes to automobiles is, all right, go to a dealer. The dealer already has an inside contract with a bank for every vehicle they sell and get them to be referred to in order to finance the vehicle. You don't get some commission inside. You don't really know about it. To you just get another new vehicle. You're removing the plastic from the seat. Ah, yes, brand new. It only has 50 miles in it. Awesome. It only has 10 miles in it. Good. It only has 200 miles in it. You got a new vehicle. It's mine. Right. You own it. But someone controls it. Well, just like all those other things, when it comes to rights, it's the same way. Many people read rights, such as this beautiful piece of work called Constitution. What are you looking at on a state level or federal level? Rights. The right of the people to be secured in their persons, houses, papers, and effect against unreasonable search and seizures shall not be violated. Awesome, right? Look at Article 1, Section 10. When it comes to being secured in your housing, your papers, and effect, those are basically contractual terms. Then there's Article 1, Section 10 that basically affirms no state shall enter into any treaty, alliance, or confederation, or law impairing the obligation of contract. Yeah, you read all this and you go, yeah, this is for me. It benefits me. The scrutiny are to the governmental actors. In other words, I own these rights. You do own these rights. Like any other given objects, like a sports team, a house, a vehicle, a city, maybe even your loved one. You own it, right? But do you control it? Those are two very distinct existences. When it comes to rights, do you own your rights? Okay, you've read it. Let's just say you actually comprehend it. You own it. What about the control of it? If you're not reading public laws relating to the extension of these basic rights, control of your rights functionally does not exist. The ownership of right does, in the sense that you will cite it all you want. When it comes to this important thing called operation of law, you don't control it if you don't know the operation of these laws called your rights. Substantive right, essential right, basic rights, and alienable rights. The things that makes contracts conscionable. the things that give that thing called consideration to any given contract, or the waiver of any given right within a contract. The operation of these laws, called public laws, is what allows you to control your rights. Knowing that the right exists is the first stage of ownership. The first stage of ownership is an awareness of something's existence. It's in your mind. You've grasped onto it. You've held onto it. But now control it. Like grabbing onto the wheel of a vehicle. All right? You bought the vehicle. You're now sitting face to face with the wheels. Now go ahead and control it. A vehicle without its master to steer it from one point to the other is useless, because it cannot be useful to you, as it cannot take you anywhere. It's looking good sitting there. You own it, but you can't use it. Ownership without control is as good as not having it in the first place. Therefore, many people beat others to the punch by grasping control and not giving the slightest care for ownership. This is where you will hear the term control everything and own nothing. People who own their houses because your name is on that deed, isn't it? That's right. You sure own it. But that's a detriment. It's a detriment because if ownership is the limitation of something and you don't seek after its control, someone else will use you, and someone else will use it against you. Someone else will use you as a cash cow to sustain themselves regardless of the economic downfall. Where inflation is rising and cost of living remains the same, the everyday man is still working overtime so they can just pay their bills, pay that mortgage, pay that car loan, still buy those tickets for those sports games. Depend on it so much just to distract themselves for a short period of time from real life's woes, such as those houses and car payments. And all those monies are going to the one controlling all those things. When it comes to rights, it is exact same way. You can own the rights by knowing it exists and cite it all you want. If you don't know these public laws, you can't be in control of it. Someone will look at you in the eyes and lie to you and get away with it. Someone will write some things on a piece of paper and riddle it with falsehood and get away with it. Although you, the one on the other hand, you just know something is not quite right. You feel it deep down, but you just can't quite put your fingers on it. You know you have the rights and obligation of contract. You know you have the right to be secured in your persons, houses, papers, in effect. Yet, this thing is just still happening to you. That's because you own the right, but you're not in control of it. Here's a little bit of helping hand when it comes to being in control of your rights. Remember, own nothing, control all. You've heard of this thing called Truth in Lending Act. Truth in Lending Act is basically a blood relative to the generally accepted accounting principle, whereby anyone who deals with monies relating to you, the everyday man, or amongst other businesses, other structures, whether financial entities or not, where they, based on Truth in Lending Act and many other blood relatives of public laws, which are the operation of law, the law being the constitutionally secured right, the basic right that's been preserved, and their operation, Truth in Lending Act being one of them, is one of the ways that you control this right. Being enacted by Senate and House Representatives of the United States of America in Congress assembled. Short title of entire act. This act may be cited as the Consumer Credit Protection Act. Consumer Credit Cost Disclosure. Title 1. Under Title 1 of this thing called Consumer Credit Protection Act is where the good old Truth in Lending Act is embedded in. I'm quite certain you've heard that phrase before. Truth in Lending Act. Any circumstance where anyone says, hey, I'm now going to play your God and say that I've given you this amount and you have to give me cash flow, strictly based on interest, not the principal. That way I can keep you in for a long time. Anyone who engages in rights and obligation of contract, even in real estate, you know that interest payments is where it's at. And that applies in any other given nature of business. Under Title I of the Consumer Credit Protection Act, Chapter 1, Subsection 101, short title. This title may be cited as the Truth in Lending Act. As we've read in Article 1, Section 10, the rights and obligation of contract cannot be annulled, nor can any law be made otherwise, abridging it. In other words, the Congress is mandated to create laws to perpetuate rights and obligation of contract. Truth in Lending Act is one of those. You've heard of this thing called rescission of signature. In a past video, I mentioned that the purpose of reserving your rights is that you are reserving your right not just as an end by itself, but as a means to an end. You are reserving your right in any given nature of contract for one purpose, and that purpose is so you can rescind your signature. You can rescind that endorsement. Hence, the signature and endorsement itself is all rights reserved. You don't reserve your right in contract just because you've seen someone said you should do it, or because you said, you know what, I'm not going to be completely tied into it. Let me tell you the truth. You will be completely tied into it if you don't know what to do after reserving said signature. What you do as a significance, or to put significance in reservation of rights through an endorsement or signature or autograph, call it what you want. The significance in that is so that you can come back and rescind your signature. You are reserving the right to do what? To rescind your signature. And the operation of law, which allows you to control that right and obligation of contract, which allows you to control the right to be secured in your papers, persons, and effect, by way of rescinding that signature, is in Truth in Lending Act. And in the note of rescinding signature, the flaw in UCC and how people do that has been entertained in this Patreon video. Just as a side note, just so you know, because all these words written on pen and paper, not a lot of people have the eyes to see it, or the mind to comprehend reading one sentence or an entire title. Two people can read the same document and comprehend it differently. One man can read it once and get it in such a great detail, where another man will have to read it 10 times to get the same level of comprehension, or half of the comprehension that another man received as information when they took a glance over it. That's the reason why we do these videos, to break it down in layman terms and relatable terms, and to create clarity. For those who are meant to get it, they will get it. For those who are stuck on belligerence and still thinks the world owes them something, they'll keep doing what they're doing. They will keep having torn clothes. And they'll keep looking for someone to fight and gnash their teeth at. But to those of you who seek clarity with sincerity, without expecting that someone owes you anything, you will see the truth in this and simply put it to use, because it's there for you to use, and it is a direct extension of substantive right by operation, called public law. This title may be cited as Truth in Lending Act. It is always made clear that there's always a congressional purpose, congressional intent. There's always a reason why Congress creates certain things, and that is the core of it. Everything else is just an extension of usually the very short content, at least in comparison to the rest of the public law. So it's important to always know what the intent of Congress is. Subsection 102, Finding and Declaration of Purpose. The Congress finds that economic stabilization will be enhanced, and the competition among the various financial institutions, other firms engaged in extension of consumer credit will be strengthened by the informed use of credit. With any given information, no matter how normal we speak of it, always know that there is always an advanced manner, such as the issue of people saying you use the birth certificate. Believe it or not, when it comes to Truth in Lending Act, that you trust falls in the category of these other firms. But on YouTube, we're definitely not speaking about that. I've noticed the crowd of people on YouTube are a bit different than those on Patreon. Crowd on YouTube have this tendency that they're owed something. As time goes on, when the appropriate flow of life comes in, certain things will be revealed here. But the more important things will be left for those who are serious and don't have a sense of entitlement. But nonetheless, this is important. This is for you. It'll be useful for you too. The Congress finds that economic stabilization will be enhanced and the competition amongst various financial institutions and other firms engaged in extension of consumer credit will be strengthened by the informed use of credit, meaning full disclosure, rights and obligations of contract, right to be secured in your papers in effect. One of the foundational principles that makes rescission of contract or signatures work is lack of well-informed decision. In fact, one of the criteria is beyond the 72-hour mark that you commonly hear about. I'm sure you've heard about that. They say you can rescind your signature within 72 hours, within 3 days. Well, that foundational principle is entertained under Truth in Lending Act, under the right to rescind your signature. But that right to rescind signature within 72 hours has exceptions whereby if you're not properly informed, that 72 hours does not get triggered until you've been properly informed. You know how many people go into these tables, closing tables, whether they're financing of vehicles or mortgages. And by the way, rescission of signature per Truth in Lending Act as an operation does not apply to refinancing of things, meaning you take one existing obligation that you've entered into where someone is purported to be your creditor, and then you add another on top of that to cancel the old one, either by way of equity or whatever else is involved. Because, of course, the so-called creditor has to do something that benefits them and cash out one way or the other for them to refinance. It's part of the consideration on their end. So the rescission, when it comes to the Truth in Lending Act, does not apply to refinance. But whatever the initial supposition of credit extension and collateral attached thereto, those things, those initial obligations and rights on one end or the other are what the rescission on the Truth in Lending Act applies to. In so many other words, whenever you refinance anything, your right to rescind is waived. Because if you were to read the refinancing terms and conditions, they oftentimes will tell it to you within their language of contract, because that's a contractual basis. And that contractual basis of refinancing, whereby a rescission of signature is not applicable, is affirmed and is in accord to Truth in Lending Act, just as a caveat. So rescission of signature, again, is only applicable to the initial entrance of contract rather than the refinance, which is another layer of a regular transaction whereby someone is claiming to be a creditor. And in furtherance of the intent of Congress, the informed use of credit result from an awareness of the cost thereof by consumers. It is the purpose of this title to assure a meaningful disclosure of credit terms. Remember, I mentioned earlier, if things weren't properly disclosed to you, the 72-hour period to rescind does not get triggered. See, everything in here within a congressional finding and intent is what's just broken down in greater words throughout the rest of the public law. That is why it's extremely important to always read the congressional finding and the congressional intent, because they will break the summary down to you in simplicity. Any part of the public law that says congressional finding, congressional intent, congressional declaration, or anything regarding Congress and why they created it, is basically the summary of it. They just summarize everything, even if the document itself is hundreds or thousands of pages. Go to the congressional findings section, which is usually at the beginning. Read it. It's usually very brief. This is almost like a cheat sheet or a cheat code that I'm telling you. The first thing you should find is the congressional finding. It's always very short. Read the congressional finding. If you do nothing relating to that body of law or statute, read the congressional finding. The informed use of credit result from an awareness of the cost thereof by consumers. It is the purpose of this title. In other words, like you do a declaration of trust, right? It is the purpose of this title to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit. Chapter 2, Credit Transaction. We'll be looking at 125 and then we'll be transitioning to the statutized version, which has an addition of the most recent part. Remember, the initial establishment of this was in 1968 and I purposely brought you to the origin of it. Then we'll be going to the statutized version, which they've added a little bit of extra thing. The basic foundation of verbiage is the same, but they've added extra sections, starting from item number E. Section 125 of Chapter 2 of Public Law 90-321. Right of rescission as to certain transactions. Right of rescission as to certain transactions. You've heard of someone say, rescind your contract, rescind it. Are they telling you why? Are they telling you how? Are they telling you the scope of it? Are they telling you the details of how it applies? Are they telling you the loopholes that you can create? I'm not talking about evoke alone, not just to call upon it, not just to use it. Well, you can deliberately create it. They put it to you in black and white. It's not some type of left-handed thing that you're doing. They leave it out for you to use. It amazes me when people complain about certain things. And the ones that don't complain about it speaks about buzzwords, such as rescind your signature. And they don't take you to the core of it and explain the details. Too often do I just sit back, look, and just shake my head and think to myself, all these buzzwords these people are throwing around, if only they really knew the power behind it. Don't worry, a step at a time. Subsection 125, right of rescission as to certain transaction. Remember, all laws are specific. This word certain meaning something very specific, a specific type of transaction. If you've read the congressional intent and you've read the short title, you know what type of transaction it's applicable to. And that's what we've been explaining thus far, with all the different examples of owning something compared to controlling it. Those examples were given because that's the type and nature of transaction that this is involved in. Those were not just some wayward or completely unrelated examples. Those examples of owning certain things rather than controlling it were given specifically because that's the nature of transaction that's applicable to the subject matter of right of rescission that we're speaking about here. Except as otherwise provided in this section, in the case of any consumer credit transaction, any consumer credit transaction, what does that term consumer or consumer credit transaction refer to? Let's go to the definition. Definition or rule of construction. A constructive trust. They declare the intent. If you really want to know how trust is structured, read these public laws. They tell you they declared it, and then they tell you what type of trust it is. It's a constructive trust. And then you define certain things. But anyway, what does that word consumer or credit transaction really means? H on the definition. The adjective, they tell you it's an adjective. It describes something. It's not the thing itself. It just describes it. Meaning consumer is a descriptive thing. It's a medium, a path to get somewhere. The adjective consumer used with reference to a credit transaction. In other words, they're telling you this term consumer would always be linked with the terms consumer transaction. throughout this law, as seen right here. In the case of any, quote, consumer credit transaction, the definition for consumer tells you that the adjective consumer would always be used in conjunction with this term credit transaction. The adjective, quote, consumer used with reference to a credit transaction. Again, as you see, the exact combination right here. In the case of any consumer credit transaction, I hope you're seeing what's going on here. The adjective consumer used with reference to a credit transaction characterizes the transaction as one in which the party to whom credit is offered or extended is a natural person. And the money, property, or services which are subject to the transaction are primarily for personal, family, household, or agricultural purposes. In other words, anytime you see this word, which would usually be combined with credit transaction, aka consumer credit transaction, which is written all over Truth in Lending Act. Anytime you see this word consumer credit transaction, it's basically referring to you in your natural capacity, meaning they hold personal jurisdiction over you, over your monies, over your properties, under the guise of the services that they're providing you, subject to the terms and conditions, aka which are subject to the transaction. Subject to the terms and conditions. If you created a promissory note to which you consented to now be on the flip side of that, where the bank says, all right, now, thanks for creating it. Now we're going to give it back to you, and now we're going to be your creditor. And you're going to use your property, as mentioned here, as a collateral, and we'll be providing a service of collecting the debt monthly, called we the mortgage servicers. And then there's a terms and condition, aka subject to the transaction. There's a terms and condition to that promissory note called a mortgage. The mortgage is the terms and condition to the monetary value called a promissory note, to which that house is a collateral for the monetary value of that promissory note. Do you see that triangle? And you, the natural person, is right in the middle of it. And they are outside of that triangle, but they have strings on it and they are controlling it. That bottom base of that triangle, they can pull the string to kind of shift a little bit. That way gravity pulls you, the one right in the middle, and you're hanging on for dear life. And if they want, they can pull the strings and close that little bottom line of that triangle. And now you go, now I have a solid foundation to stand on. At least you think. They're controlling it because you don't know how to control your basic right to be secured in properties, papers in effect, by knowing languages of things like these that are written on pen and paper as to how they will control you and potentially how you can get out of it. And I use that qualifying term potentially because, again, two people can read the same thing and get different comprehension of it. The least I can do is show it to you and explain it to you. Your comprehension of what's being shown and explained is up to your own essence. The adjective consumer, used with reference to a credit transaction, characterizes the transaction as one in which the party to whom credit is offered or extended, offered meaning it's not been finalized, or extended meaning, okay, you've accepted it, awesome, you're now formally our slave, is a natural person, meaning the presumption here is that we know you don't know how corporate veil works. We know you don't know how the principle of control and own nothing works. We know you don't know anything about using trusts, the varying degrees of trusts, like an express trust or a 508. We know you don't know the principles of a contract, because if you know how to use a trust, then you know how to embed principles of a contract and things that will protect you into those things. But we know you don't know all those. So we're just going to create a law under the presumption that you're always going to be personally liable. Don't people going about natural person, artificial person? Everyone wants to be a natural person, right? Right. But then they want to make the excuse that, oh, well, all these mortgage contracts, all these financial stuff, it's for the legal, it's not me. But it's not me saying this. The congressional intent is saying that you're wrong. All that is under the presumption that you're being held liable personally as a natural person. So now you see all that contention where people going about, oh, they're dealing with enslavers and not me. Well, the congressional language of how they can enslave you and how you can free yourself strictly deals with the fact that anyone they interface with is always going to be a natural person. And the extension of said natural person being their monies, properties, or services relating to it and you is being held under their strings, unless you know how to get out of it, which is one of the things we're speaking of. To know you can rescind your signature is not enough. To know the details of how and why is the key. There can be a house full of hundreds of people who know all the terminologies from the front of a Black's Law dictionary all the way to the back and can recite it like the Bible. And then there could be one man outside of that house who knows why and how, but might not be able to tell you the page number of what a term is in a Black's Law dictionary. The reason why that man is outside of that house and is out there with more option in the open world compared to the ones confined within that box is because they know the why and how. That is to say, reading Black's Law dictionary till you know the page number and all the rest of the card are assigned to certain terminologies, if you know that that's the purpose of using the law dictionary. Knowing all that means nothing if you don't know the why and how of its applicability. The answer is always in the public laws. The adjective consumer is used with reference to a credit transaction characterizes the transaction as one in which the party to whom credit is offered or extended is a natural person, and the money, property, or service which are the subject of the transaction are primarily for personal, family, household, or agricultural purpose. They fine-tune the language and intent so much to agriculture, meaning, okay, so you own farmland. Not a problem, because remember, land are zoned differently. And this is part of the thing people don't even consider. So now that we know what the term consumer credit transaction means and who it's applicable to, let's move on to the rights of rescission. Subsection 125. Rights of rescission as to certain transaction. A certain transaction, except as otherwise provided in this section. In the case of any consumer credit transaction, which we've defined what it is, in which a security interest, in other words, a collateral, is retained, meaning is held by someone by their strength. And the way that it is retained is through that terms and condition, aka the subject of the transaction, aka the mortgage, aka the loan agreement, or acquired in any real properties, things dealing with land. Remember, this is not just limited to land. It applies to car loans also, which is used or is expected to be used as the residence of the person to whom credit is extended. The obligor shall, meaning you, the one who is obligated to perform. That's who the obligor is. Don't let all these fancy words fool you. Don't let it carry you away. It just means obligor is just whoever it is that has to perform, aka the debtor. That's what the obligor is. The obligor shall, and we went over this in the video regarding how to put your vehicle in the trust and make the express trust the first lien holder. The obligor shall have the right to rescind the transaction. The obligor, aka the debtor, shall have the right to rescind the transaction until midnight. That's when their books reset. So there are different stages of how books reset. The smaller stages rescind every midnight. And then the next stage to that is every business weeks, 7 days. And then the other stage to that is each quarter, every 3 months. And then the next stage to that is fiscal year. The obligor shall have the right to rescind the transaction. What type of transaction? Any transaction dealing with real property. Any transaction dealing with a natural person. Any transaction dealing with the money of the natural person. Any transaction dealing with the property of the natural person. Any transaction dealing with services relating to that natural person. Any transaction dealing with any use for personal, family, household, or agricultural purposes relating to the natural person. In other words, it's not just limited to land, just so you know. Even though the language makes it seem as though it is, but it's not limited to it. Anything you have a loan against, and there is a terms and condition, and something is used as collateral, this applies. And the obligor, aka the debtor, shall have the right, shall, not may, not might, not probably or could, subject to other things, but shall. The debtor shall have the right to rescind the transaction until midnight of the 3rd business day following the consummation. Consummation is another word for the coming together of two things, meaning after the agreement. So by the midnight of the 3rd business day, meaning you're signing on Friday, Saturday and Sundays are not business day. So by Tuesday, midnight on Tuesday, you have the right to rescind. If you sign it on Monday, by midnight on Wednesday, you have the right to rescind. If you sign it on Wednesday, by midnight on Friday, you have the right to rescind. The obligor, the debtor, shall have the right to rescind the transaction until midnight of the 3rd business day, following the consummation, following the agreement of the transaction, or, meaning the first criteria is 3 business days after you've entered into an agreement, you can rescind the signature, or 3 business days after the delivery of the disclosure required under this section and all other material disclosures required under this chapter, whichever is latter. Ladies and gentlemen, here's a loophole. Whichever is latter, meaning if at any given point they did not give you the full disclosure as to the terms and condition, and at a later date you request for it, which you have the right to. And this is not saying, hey, we've changed their servicer. No. But it does mean every time they send you those letters to say, hey, we've updated our terms of service, do you know you can trigger right of rescission 3 days after the delivery? If they date it January 1st, regardless of whether they update the term of service or not, or whether you requested it because you saw, something is missing here. And then they dated it January 1st, but you didn't receive it until January 30th. Well, that January 30th is the day to which the 3-day business day period is triggered for you to rescind your signature. Whichever is latter, 3 days after you enter into agreement of the transaction, or 3 business days after the delivery of the disclosure required under the section and all other material disclosure. All other material disclosure involves and includes them updating their terms and services. Keep that in mind. So the first criteria that allows you to rescind signature within 72 hours, aka 3 business days, is 3 business days after you enter the transaction. That's 1. Or 3 business days after the delivery of the disclosure required, meaning you can ask them, even if the agreement has been signed for 5 years, ask them for certain things and they send it to you And after they send it to you, you realize this was not disclosed in the first place in the closing table 3 years ago. The moment you realize that, it's called a discovery rule, and it's called equitable tolling. Oh boy. That 3-day time period triggers. That's 2. Or 3. All other material disclosures required under this chapter. Which is, we've updated our terms and conditions. And many more other things which they mentioned themselves. They didn't give you the loophole, whichever is latter. If they said whichever is earliest, that means once the time is over, that's it. But whichever is latter means if it happens today, and you figure it out today, and the disclosure was not provided, and it was only provided today, even though the agreement has been active for 3, 5, 10 years. But the disclosure was later made today. Today being the latter time period. That 72-hour business day triggers for you to rescind your signature. Do you see what's going on here? Rights and obligation of contract is so cold and so beautiful that once you really get how it works, you will see the reason why they call America the land of the free. You, the one who lives in it. If you don't know how it works, it will be used against you to control you. Sure, you own that physical object. You own your rights. But are you really controlling that physical object and that right? Or is someone else using that physical object and that right and obligation of contract against you? These are the basic questions you should ask yourself. If you don't know the operation of law that allows you to reach far, you're not controlling jack. Whichever is latter. By notifying the creditor, here is where the notice of rescission comes in. In accordance with regulation of the board of his intention to do so, all you have to do is notify the creditor that you're rescinding your signature and basically evoke one of these 3 elements as to the criteria that qualifies said rescission. So now what is their obligation once you make your move? The creditor shall clearly and conspicuously, meaning no pussyfooting around, disclose in accordance with regulation of the board to any obligor, aka the debtor, presumably you, in a transaction, meaning within the terms and condition attached to that right and obligation of contract, attached to that object being used as a collateral that's linking you to constantly give them cash flow. They have to give you disclosure within that agreement, subject to this section, the right of the obligor, you, your right, under this section, under your right to rescind. The creditor shall also provide in accordance with regulation of the board. That's where you will get regulation Z, regulation D, regulation B, so and so, which is in Title 12 of Code of Federal Regulation when it comes to bank and banking. Look it up. Just type in Title 12 CFR. It will give you 2 distinct things called bank and banking. That's their obligation to do and know all that. But just so you know, as a heads up, if you want to use that birth certificate, if you don't know bank and banking and things dealing with details of those natures, you just engage in some hobby, which is fine too. But anyway, let's look at what this word rescission means before we go any further. Rescission, according to Bouviers, the termination of a contract. So when lack of disclosure occurs, or when you trigger it, and you rescind your signature, that means you terminated all those obligations that they put as a nozzle on your neck, your wrists, and your ankles. Rescission It's a termination of a contract through its abrogation or annulment by words or act of the parties, or by a judgment or decree of the court. The termination of a contract by mutual consent of the parties or pursuant to condition contained in the contract, which is the reason why they have to point out to you, according to the Truth in Lending Act, that the creditor shall clearly and conspicuously disclose, in accordance with regulation of the board, aka banking regulations, that they're obligated to, for the purpose of you making well-informed decision according to the intent of Congress we read at the beginning of this video. To any obligor, aka you, the presumed debtor, in a transaction subject to this section, whenever you invoke your rights to rescission, based on the principles of how rescission works, the other party is supposed to mutually consent to it, based on the language of the contract. Otherwise, it's an unconscionable contract, meaning you can't get out of it, meaning it's unconstitutional, meaning it abrogates the rights and obligation of the contract, meaning it abrogates your right to the security of your papers in effect. Any contract that you cannot get out of is an unconstitutional one. And the moment that you evoke rescission, they're obligated to respond to it, so long as you know what you're doing. And usually you will find elements of fraud. On Patreon, we went over about 7 different types of fraud. A lot of people say about fraud. What type of fraud are you speaking about? You need to know that to be able to properly rescind your signature. And in order for it to be a decree, this is where the use of a notary comes in. The termination of a contract by mutual consent of the parties or pursuant to a condition contained in the contract or for fraud. Many can step outside of the contract and say, you know what, based on other things or based on the contract itself, if you're saying the contract does not give me the ability to get out, then guess what? The contract is one of the 7 types of fraud. Failure of consideration, which we made a video about some of the elements, the core of what makes a contract. This video. Or a material breach or default. The reason why I'm reading this definition is to get to this part where it says material breach or default. See this part where it says decree, when I mentioned using a notary? This is where you use a notary protest. Did you know the primary purpose of a notary protest, that's affirmed in the state legislature and in UCC, is meant to be tied with rescission of signature? Because by operation of rescission contract that you can invoke, it's meant to be done through a protest, because you are supposed to evoke default. Because normally whoever has been making money from you by using you as a cash cow would not want to show you the part of the contract or would not want to mutually agree. And that's fine, because based on the right of rescission, you can invoke a decree by defaulting them, called notary protest. Now tell me, the people who know about rescission of signature, do they know that it's meant to be used with a notary protest? Do they even know that notary protest has a specific language within the UCC on the state and federal level? The termination of the contract and restoration of the contracting parties substantially to their status quo, meaning taking them back to the position they once were before or that they were supposed to be in. The norm, aka what is ought, aka equity. Rescission is an act of treating a contract as broken, snap it and throw it away, and desisting, like a cease and desist, from further performance. It's been burned. It's over. It's ended. It's finished. Where the other party to the contract has been guilty of a breach of it. It is an abandonment of the contract, but it is not, quote, rescission technically speaking. It is merely the acceptance of the situation which the wrongdoing of the other party has brought about. The contract cannot be valid because something is wrong with it. And what will be wrong with it is based on the second and third portion of the 3 ways to which you can invoke a rescission. Moving on. The creditor shall clearly and conspicuously disclose, in accordance with regulation of the board, to any obligor, aka the presumed debtor, aka presumably you, In a transaction subject to this section, the right of the obligor under this and the transaction subject to it are the ones that we went over at the beginning. The right of this obligor under this section, the creditor shall also provide, in accordance with regulations of the board, an adequate opportunity to the obligor to exercise his right to rescind any transaction subject to this section. This subsection 125 just basically explains to you that you actually have the upper hand, even if you are presumed to be the debtor. All these people are always jittery about wanting to be the creditor. If someone who knows what they're doing comes to you at the other hand as a debtor, they will kick your ass. I'm revealing this to you because most people are under the status of a debtor. But just because you're under the status of a debtor doesn't mean you always have to play the role of a defendant. Go at it. Well, you can only go at it if you know how to control what you call your rights. If someone else is not controlling it or controlling you or using it to control you, this is part of how you control your right and your life. What we're going over here is part of what principles of contract entails. No one else will tell you or show you these things. As always, either because they don't know, or if they know, they don't want you to know. But my thing is, the sky is big and wide enough for many birds to fly. You can know this too. There's nothing wrong with it. Believe or not, the more free you are, you listening to this, whatever state of mind you have, believe or not, your freedom is equivalent to my freedom also. Because no one man is an island. And the extent of the things that I can disclose on YouTube, I'll do so. The rest that cannot be disclosed, the trail will be given to you here. Because the least you cannot say is that someone is not showing you. You cannot say someone is not showing you. You're not just being told rescind your signature. It's been explained the condition as to how you can trigger it. Literally, you can take your life into your own hands. And then how you do it, why you do it, and the law that affirms it. It's been given to you. Listen to this. When an obligor exercises his right to rescind under subsection A, which is what we just read, he is not liable for any finance or other charges, and any security interest given by the obligor becomes void upon such a rescission. You dealing with child support? You should be doing a rescission of signature along with it. Reserve your rights, but do certain things simultaneously, such as a notary protest and a cease and desist of collection attempt. Remember, this public law is tethered to consumer related matters. In other words, they're telling you that Fair Debt Collection Act, that we went over the details of how to do it on Patreon, you better be putting it to use also. All these things go hand in hand. Within 10 days after receipt of a notice of rescission, the creditor shall return to the obligor, meaning now they have a timeline to perform. Within 10 days after receipt of a notice of rescission, the creditor shall return to the obligor any money or property given as earnest money, meaning a deposit, down payment, or otherwise, and shall take any action necessary or appropriate to reflect the termination of any security interest created under the obligation. For those on Patreon page that's been keeping track of the Infinite Banking series of video, this part is for you. There will be a point when you start to do certain things and you realize you need to get out. This is the answer for you, believe it or not. Keep this in mind. If the creditor has delivered any property to the obligor may retain possession of it. Oh man. Upon the performance of the creditor's obligation under this section, the obligor shall tender the property to the creditor, except that if the return of the property in kind will be impracticable or inequitable, meaning if the property is yours to begin with, how can you use something as a collateral if you don't already own it? And if you rescinded the signature, why would you be relinquishing the property onto them? That will be inequitable. The obligor shall tender its reasonable value, If the creditor has delivered any property to the obligor, meaning if they've given you anything of value in the first place, which in most cases, that's really not the case. Especially with real property such as houses. Remember, you're using that house as a collateral. To use something as a collateral, the presumption is you already own it. They didn't give it to you. You owned it. So the property you'll be relinquishing will be the monetary value of that promissory note. But the house is yours. I'm not saying this. Listen to what they have to say. If the creditor has delivered any property to the obligor, the debtor, the obligor may retain possession of it. If the creditor has delivered any property to the obligor may retain possession of it. Obligor being the debtor. If the creditor has delivered any property to the obligor, the debtor may retain possession of it. Upon the performance of the creditor's obligation under this section, meaning if they're in honor of their rescission, the obligor shall tender, the debtor shall tender the property to the creditor. The property that they have in possession that they purportedly gave you is a supposition of monies and mortgage situation. They're saying we're the one who gave it to you. Because you agreed to create it and then make us the creditor. So we own this promissory note. Okay, cool, not a problem. The land on the other hand that's being used as a collateral is yours because you're the one placing it as a collateral. Except that if the return of the property in kind will be impracticable or inequitable. So now they say, you know what, the land is ours also. Even though there's an existence of that. They already took the note. They can't take the land also. That's the parting gift for them. The notes. Because they have a lot of shareholders and trust attached to it. But what if they just want to be hardcore and want to say, I'm going to take the property? Well, they can't because it's inequitable to do so. Remember, we read the definition of rescission, and it mentioned all the parties substantially back to their status quo, back to where everything is supposed to be. That's equity. Rescission is an equitable right, and it will not allow anything inequitable. They take the promissory note that they want so bad, because that's what they want, the money. That's why they trick you and create all this system. The money. That's the equity on their part. The equity on your part is you keep the land and all the appurtenances called the house. Upon the performance of the creditor's obligation under this section, their obligation is to acknowledge their rescission. The obligor shall tender the property to the creditor, whatever property they've given you, aka if the creditor has delivered any property. The only presumption of what they've given to you as a property of theirs is the promissory note, even though we know that it's yours, but you've waived the right for it to be yours under the condition that you get to stay in the house. So now they say the money is theirs because they're saying we're the one who lent it to you, even though you lent it to us, but you waived the right to make a claim to it because you've traded the house for it. So now the note is theirs. That's the equity behind it. And since they're taking the note, you're taking the house. And if they say they want to take the house, then it's inequitable at that point, and it is against Truth in Lending Act. So now you see rescission is not the only thing you can enforce under Truth in Lending Act. These small words in these legalese, if you don't comprehend it, you'll not be able to enforce it. This is what I mean when I say two men can read the same thing and get two different comprehension. The least you cannot say is someone is not bringing this clarity to you. Tender shall be made at the location of the property or at the residence of the obligor, at the option of the obligor. Meaning this exchange is supposed to be finalized and closed. Meaning the second closing based on the rescission that you're now controlling is supposed to occur at your property. You, the presumed debtor, if you choose. If the creditor does not take possession of the property within 10 days after the tender of the obligor. Ownership of the property vests in the obligor without obligation and his part to pay for it. So let's just say worst case scenario, they're saying this house is ours. If after 10 days that you tendered that rescission of signature, that is if they're saying the land is theirs also, the ownership of the property vests in you, the obligor, aka the debtor, without obligation on his part to pay for it. Oh my goodness. When I say the system is perfect, the system is perfect. All these people dealing with mortgage issues, they're talking about everything else under the sun, but the simple, basic, cutthroat, direct thing that they could be put into use as a tool. It sickens me. That's the reason why I'm revealing this. Like, look, you can do this, and here is it, and here's the solution. All these other plethora of things people are doing, you're giving yourself a headache. So now, let's just say you even now want to sue. All these things, if you set it up stage by stage through the notary protest, and you invoke all these foundational principles in Public Law 90-321, Truth in Lending Act, this is just one section, subsection 125, right of rescission, that we're still reading. This is a 22-page document. It's game over. Notwithstanding any rule of evidence, written acknowledgement of receipt of any disclosure required under this title by a person to whom a statement is required to be given pursuant to this section does no more than create a rebuttable presumption of delivery thereof. Let's read that a bit slower. Notwithstanding, regardless of any rule of evidence, meaning based on rights and obligation of contract, rule of evidence makes no difference here, because the terms and conditions that controls one's ability to rescind their signature, which is the same section that we're still reading, right of rescission. This right has nothing to do with any formal rules of evidence, because the language of what governs this ability is what we're stating here. So notwithstanding any rule of evidence, written acknowledgments of receipt of any disclosure required under this title by a person to whom a statement is required. Meaning, the moment you do your rescission, the other party, aka the creditor, is mandated within 10 days to tell you, hey, based on the contract that we have, which is the mortgage or whatever the loan agreement for the vehicle is, yes, you have the right to do this. Or whether you write to them and they get the notice, regardless of any written acknowledgement and anyone's requirement to say, yes, I have received it. You know, like the Fair Debt Collection Act, they're supposed to respond to you and say, hey, we're investigating it, within 30 days we'll respond, before they give you the Kool-Aid of it being verified. Regardless of whether they give you a notice of it, that notice of them saying, all right, we received your letter, we're doing something about it, it does no more than create a rebuttable presumption of delivery thereof. Any given stage, you can always rebut anything, and your mere rescission and their acknowledgement of it is not the end of it. And it goes for them also. They can always rebut your rescission. But that's the reason why we read the definition of rescission. In case you want to play hard, there's a way you can grab them by the balls. Through a decree, through a default. Do it privately, and then take it into public court to balance the books. A wise man speaks with few words, because it's under the assumption that the one receiving the information is wise enough to comprehend the details of what's being said. Despite the fact that I repeat a lot, so much deliberately, just so people get it. But moving on. Know that each letter, C, B, A, all these sections, if you really understand the power inside of it, for you, it's gain. D, the board may, if it finds that such action is necessary in order to permit homeowners to meet. bona fide personal financial emergencies, prescribed regulation authorizing the modification or waiver. Waiver being one of the principles of contract that we also went over in this video. Waiver of any right created under this section to the extent and under the circumstance set forth in those regulations. The section does not apply to the creation or retention of a first lien against a dwelling to finance the acquisition of the dwelling. Meaning anyone can still be the first lien holder. Let's stop there for now. More than enough has been provided to you to solve any given problem when it comes to any given loan. But use it carefully. Rights are like fire. In controlling it, it might spread too far beyond your control. So listen to these words. Not twice, not 3 times, not 4, not 5. Listen to it until you truly get it in your spirit. And you know the importance of using trust to move things and do things. I'll say that and I'll leave it there. The statutized version continues beyond D and E. It goes into exempt transaction. It goes into time limits to exercise it. It goes into additional relief and limitation of rescission. And it goes into rights of rescission and foreclosure. It goes into the tolerance of disclosure, applicability, right of recoupment, and state. If you're living in a condominium or some unit housing where there's apartment complexes, this right of decision does not apply. And it tells you in E1, section 1602W basically says the same thing. And remember earlier when I spoke about refinancing and it not applying? Well, E2 explains that. 3 lets you know that rescission of signature is not applicable where an agency of the state is the creditor. Do you know that with child support, despite the fact that some entities who are acting as a debt collector claim to be the agency of the state, if you dig deep, you realize that they're really not. They're private entities. So don't let them pull that wool over your eyes. And the 4th thing that's inapplicable is advances on the pre-existing open or credit plan if a security interest has already been retained or acquired and such advances are in accordance with previously established credit limit for such plan. In other words, it's a form of refinance, but specifically for credit lines such as a revolving line of credit. Because you can do that with a revolving line of credits too. You can do matters of financing, things like that. The statute of limitation. Remember, we read that at the beginning portion. It says, well, anything that appears at a later date, you can always evoke it. But then they put another clause of statute of limitation. But keep close attention that while I was explaining that, when it comes to you how to evoke it at a later date, something called equitable tolling was briefly mentioned. We made a video on that on Patreon. But if you don't know about how that works, then this applies. Statute of limitation of 3 years. An obligor's right of rescission shall expire 3 years after the date of consummation, and they enter into agreement of the transaction or upon the sale of the property, whichever occurs first, rather than latter. Notwithstanding the fact that the information and forms required under the sections or any other disclosure required under this part have not been delivered to the obligor, except that if 1, any agency empowered to enforce the provision of this subchapter institute a proceeding to enforce the provision of the section within 3 years after the date of the agreement or transaction, or 2, such agencies found in violation of this section, or 3, the obligors, aka the debtor's right to rescind is based in whole or in part on any matter involved in such proceeding, that the obligor's right to rescission shall expire 3 years after the date of the agreement or transaction, or upon the earlier sale of the property, or upon expiration of 1 year following the conclusion of the proceeding, or any judicial review or period of judicial review thereof, then if they sue you for the transaction, like the defendants. There's no statute of limitation in 3 years. It gets told. but that's only to their benefit. Know the tolling of statute of limitation that exists to your benefit. And if you were to bring a claim under rescission and you sue them subsequently after doing the right things explained in here, you can bring other claims, such as fair debt collection. Claims not relating to right to rescind, limitation of rescission. The limitation of your right to rescind cannot come out of them sending you a notice that you have the right to rescind. Rescission, when it comes to foreclosure, they're telling you even if it's non-judicial or judicial, you still have the right to rescind. And so long as you follow the foundational principles mentioned in how to rescind it. It's the time period and all the things are spoken of. And it tells you you have the right to bring other state law tort actions. And this can be done with any contract after the year 1995. Until next time, take care. Truly, really, best of luck. Remember, no one owes you time. No one owes you explanation. And no one is compelling you to do anything. Your life and your rights are in your hands. Stop having a victim mentality. The world is filled with infinite possibilities. The moment you always complain that someone is supposed to give something to you or someone is doing something that's not satisfactory to you, you're limiting yourself, not the one that you're musing about. Just keep that in mind. Because the same person that you're musing to, harking and barking to today, might be the one to assist you tomorrow. There's a West African proverb that says, as you close your eyes for the bad people to walk by, or the bad circumstance to walk by, good people will walk by along with them, and you will never see them. Same thing applies with circumstances. So relax your incompetence. Use your discernment. And realize that the world does not cater to you. You have to care enough for yourself by using common sense and realizing that opportunities exist beyond the limitation that you merely perceive. Until next time, take care. Best of luck. I have a Patreon page and I'm inviting you to come join. Whether you're interested in discharge, we show everything about how it's done and my own experience. Consistent posts are made explaining many things regarding said discharge. Many will seek and simply wouldn't find. Those dealing with mortgage issue or want to know more about it, we speak of it. For those dealing with basic stuff like traffic issues, we speak about the solution and I show it from my own experiences and how I permanently prevent any such issues. Those worrying about trust, different types of trust, we go over so many things consistently regarding trust. We show the IRS manuals. Those who are interested in suing and making money through debt collection or other means, we go over it, we show it. I show my own settlement checks and the things that I've done as a personal experience. Those interested in banking, we show subtle details and intricacies of the things that I have learned. For those interested in other things like the IRS forms and how to put it to use, we show it, explain the details. For those interested in court-related matters and intricacies, we always show it. For those interested in the spiritual aspect of things and how it works, we show and explain it. Those with child support matters, we explain and we show everything in detail also. Great puzzle pieces that can never be found in other social media platforms, but we explain it all as it relates to many different things. For those interested in express trusts and the issue of how not qualifying for taxation, which I call dinking, how it relates to any other type of trust or any other affairs, and how you can intertwine your affairs into the different types of discharge that exist and lack of qualification for taxation. Speak about it. The truth about really recusing attorneys and the whole foreign agent registration and attorney lawyer number, we speak about it. Speak about how to really bring about juries, and some of the comment section asks good questions and greater answers are given. Speak about how to get and use
tax exemptions for vehicle use and sales. You don't have to belong to some organization. You can actually get yours according to the language of the legislature within your state. Go over the details that a lot of people mentor about regarding Article 1, Article 3. What really makes a court? It's not limited to just your paperwork. Most people don't know. We go over business matters for those with actual businesses, S Corp, C Corp, LLCs, those who are business minded and those who make monies. Go over other things that a lot of people don't know functions internationally. We speak about a lot of other spiritual related matters. Details on how to bring criminal charges, what it truly means to bring criminal charges, what a bill of particulars is, how to recuse a judge, details of the parliamentary rules in court and legislature, different things about standard of evidence and burden of proof, different things that a lot of people will speak of, discovery. But did you know there are 6 types of discoveries? You know how to intertwine your LLCs and S Corps with an express trust, how to not make them taxable? Do you know when Trinity versus Pagliaro really is invoked? Do you know how to use your home as a home office? And the many details involved. Go over the injunction and how to enforce the different types of injunctions that exist. The intricacies of how data brokers exist and how they steal information. Not just the credit bureaus, but many data brokers and how you can prevent them. We go over grants, getting grants. We go over issues and solutions of CPN and how they're created. There are about 6 or 4 to 5 different parts that were created. We go over caveats where people say sue them, but they don't really know. We go over the things to do after you sue them. We go over the issues of privacy and technology. The whole thing about perfection of security interest, UCC, and how to use it and how to monetize the birth certificate, all that. We go over the details. There are a lot of principles and doctrines people don't know about that we go over. Go over how to really do the copyright and the details involved in it. Go over how to simply do a trademark. It's far more easier than you think. All these people telling you go to a trademark office, do this, write this letter. It's not that difficult. Go over how to fill out the GSA bond box at a time, and so many more. How to get settlement checks, how to put your vehicle in a trust. I show you from my own experiences, form for form, step by step. Go over the different types of relief to be granted. The type of relief you seek invokes the type of jurisdiction that you fall under. All these people speaking about chancery, equity, and law, common law. The relief that you seek is directly tied to the type of jurisdiction. Go over the CPN, how it's created. Go over how to obtain bonds, where to do it. Go over the different types of discharge and some more. We explain each of those types of discharge. We explain how trademark and copyright is affiliated with asset protection. We go over how to prove trust. We go over the different types of fraud. We go over the importance that many people will never know. So many more. I show my own experiences in the audio calls from court cases of how I get different types of settlement checks. Go over the different types of discharge. There's so much more that it can't even completely be spoken of here regarding trust. We go over how to create it step by step, and many more things that will never be shown on YouTube or any other platforms. Go over other principles that people don't know about when they speak about statute of limitation. Well, fraud does have a statute of limitation, but do you know how to subvert it? As to why that phrase fraud has no statute of limitation to bring it to life, most people don't know. There's so many things that we speak about. We speak about how to garnish people's checks and people's property. There's a form that you use for that. People don't know about it. Speak about details regarding foreign trustees. Speak about spiritual related matters. And on the Instagram page, if you get to join, come on over. There's also a Facebook page where questions and answers are posted and other reminder links to certain videos are shown. Until next time, take care. Best of luck.